that we had left, and then we can further move on with another lecture, with another session that we were supposed to take today. So yes, I welcome all of you. I'll directly. So yesterday we saw what is workplace harassment. We met Rita, we heard her story. She was facing workplace harassment at her office. Then we read about what is workplace harassment exactly. We learned about types of workplace harassment. Then we learned about what are the forms of workplace harassment. So yeah, we learned about what is verbal harassment, then what is sexual workplace harassment. We learned about intimidation. We learned about religious harassment. We learned about gender-based harassment. We learned about age-based harassment. Try to remember whatever you are looking at these pictures. So try to remember through the slides. Try to remember Rita's story. Then we have got disability bullying. We've got unwanted advancements. Then okay, yeah. So have you experienced any of these? Okay. Then you take an action. But how to fight against this? With courage and with the help of protection provided by law. And we were at complaint procedures. Now that we have gone through workplace harassment, we will just try to understand the complaint procedure. If you or any of your friend or any of your relatives or anyone around in your circle is going through this. So let us understand about the complaint procedures for workplace harassment. So we'll begin for yesterday's continuation lecture. Yes, to appeal to a court in a workplace harassment case in India, you typically have to follow these. So if you're experiencing any of workplace harassment, any forms of workplace harassment, and if you want to appeal to the court, you have to go through these steps. So the first step is to file a formal complaint. Yesterday we saw that before going to the court, you should first report the harassment to your employer or the internal complaints committee. I told you that we'll learn about internal complaints committee as well. So yeah, so the first step is to report the harassment to your employer, or either you can report it to your employer or you can report it to internal complaints committee if available at your workplace. Also, if internal complaints committee is available at your workplace, then you can report it to the internal complaints committee, or you can report it to your employer. So most workplace harassment cases are resolved at this stage. So usually most workplace harassment cases are resolved at this stage, and you may gain relief through this. But even if you don't, then you can further seek legal counsel. So if the internal process do not provide a satisfactory resolution, or if your employer fails to take action, consult a legal professional experienced in employment law or workplace harassment. They can advise you the best course of action. So your step 2 has to seek legal counsel. If you don't get relief through the complaint that you made to the employer or internal complaints committee, your third step has to be file a complaint with the local complaints committee. If your workplace does not have an ICC, so we learned about internal complaints committee, and now we'll refer it to as ICC. So if your workplace does not have ICC or has less than 10 employees, and you are unable to resolve the issue internally, and for some or the other reason, if you are unable to resolve the issue internally, you can file a complaint with local complaints committee in your district. So they will investigate the matter. We'll go through what is ICC and what is local complaints committee. So yeah, first let's see what is ICC, internal complaints committee. Every organization with 10 or more employees is required to establish an internal complaints committee to address complaints of sexual harassment or any kind of harassment. The ICC is responsible for conducting inquiries into complaints of harassment and taking appropriate action. So what does ICC do? It conducts inquiries into complaints of harassment and takes an appropriate action. So ICC has to take an action as well. But again, like we saw, every organization with 10 or more employees, any organization that has 10 or more employees has to establish an ICC to address complaints of harassment. So I hope you have understood what is ICC. So every organization that has 10 or more employees has to establish an ICC. Okay, now what is Local Complaints Committee? The Local Complaints Committee is a body established by under the Sexual Harassment of Workplace of Women at Workplace Prevention, Prohibition and Redressal Act 2013 in India. It is responsible for addressing and resolving complaints of sexual harassment at small workplaces and organizations that don't have internal complaints committee. The Local Complaints Committee, that is the LCC, receives, investigates, and takes action on complaints to ensure a safer workplace environment for women. So, what is Local Complaints Committee? It is a body that has been established under the Sexual Harassment of Women at Workplace Act 2013. So, it is responsible for addressing and resolving complaints of sexual harassment or harassment at small workplaces and organizations that don't have the ICC. So we saw ICC. So ICC, just try to remember ICC. 10, if an organization or a body has 10 or more employees, then it has to establish ICC. But if ICC is not established, it hasn't been established, then you have another option, that is Local Complaints Committee. Okay. So if not ICC, if you don't have ICC at your workplace, you can file a complaint to the Local Complaints Committee, and Local Complaints Committee has to investigates, takes action and complaints to ensure a safer workplace environment for women. Okay, I hope you have understood the differentiation between ICC and LCC, and this was your step 3. So first, again, remember, try to take action and try to file a complaint with ICC. If not established, if not there exists, then you can file a complaint with LCC. And your second step is to take legal counsel, is to seek a legal legal counsel. Yes. So now that we've understood ICC and LCC, we'll understand further complaint procedure. So then your third option, or the third step you must take, is file a complaint with the police. If the harassment involves criminal conduct, you can file an FIR, that is the first information report, with the police. This is especially relevant in cases of sexual harassment or assault. So maybe, if you are facing a more severe type of harassment that includes sexual harassment or assault, then you can file an FIR or file a complaint with the police. So you have to visit the police station and you have to file an FIR. And the next step is approach the labor commissioner. For certain employment related issues, you can approach the labor commissioner in your state or region. They may be able to help mediate or resolve the matter. So this is another option for you. You can approach the labor commissioner as well. And I think, yes, and it is for certain employment related issues. So yeah, you can approach the labor commissioner in your state or region. They may be able to help mediate or resolve the matter. Approach the court. If other avenues do not yield any satisfactory results, if taking all these steps, even after taking all these steps, if you're not able to gain satisfactory results, then you can approach to the court within your jurisdiction over your case. So in India, this could be a civil court, the session court, or a specialized employment tribunal, depending on the nature of the case. So depending on the nature of the case, you can approach to either a civil court or a sessions court or a specialized employment tribunal, depending on the nature of case and how severe it is and what form of harassment you are going through. Okay, so your next step is to prepare a strong case. Work closely with your legal counsel to build a strong case. Again, remember the story of Cherry. What was her first step? She gathered evidences. Always remember that. So your first, again, to prepare a strong case, your first step has to be gather evidences and ensure your complaint is well documented. Again, one more thing. Yesterday, I told you a story, an incident about the lady police officer who went through sexual harassment from her senior officer, and she went directly to the commissioner of police. What was, again, try to remember the story. What was her first step? She gathered all evidences, all the messages that senior officer had sent to her about her harassment. She took screenshots. She had mobile recordings. So try to remember those things. To prepare your case strong, you have to do all of these things. You have to gather evidences so that you have a stronger case. Again, file a case. Your lawyer will help you to file a case in the appropriate court, outlining the details of the harassment and the relief you seek. So this is the option, again, to approach the court and file a case. This is the option. If the other options, that is the ICC, filing a complaint with the ICC or LCC fails, or filing a complaint with the police fails, which happens very rarely, but if still you are not getting satisfactory results, then you can file a case or you can approach the court. Yeah. So attend your hearings, await your court decisions. It is important to consult a legal professional to understand the specific legal procedures and requirements for your case, as workplace harassment cases can be complex and may involve various laws and regulations. Okay, now that we have understood how to file a complaint against harassment, workplace harassment. So yeah, one landmark judgment was the case of Vishaka versus State of Rajasthan in 1997. This case laid the foundation for legal measures against sexual harassment at workplace. The Supreme Court of India issued guidelines. After this case, the Supreme Court of India issued guidelines to prevent sexual harassment, which later led to the formation of Sexual Harassment of Women at Workplace Prevention, Prohibition, and Redressal Act 2013. So this was the landmark case, which eventually led to this establishing formulation of Sexual Harassment Women at Workplace Act 2013. Yeah, let us see what is this case. What does this case talk about? So yeah, Vishaka versus State of Rajasthan, 1997. So the Vishaka versus State of Rajasthan case again was a landmark judgment. Okay, we'll not go through that now. We'll go through the background. The case was prompted by gang rape of a social worker named Banwari Devi in Rajasthan, India in 1990. Okay, in Rajasthan, India in 1992. Banwari Devi had attempted to prevent a child marriage, which angered some influential individuals in her village. As a result, she was brutally raped. So what happened one day? So Banwari Devi was a social worker, and there was this a marriage that was happening, a child marriage that was happening, and to save the girl from the child marriage, to save the bride from the child marriage, Banwari Devi went to the place and she stopped the wedding, and eventually, which led to the cancellation of child marriage. But due to this, there's some individuals from her village were quite angered, and maybe some of them were also from the family of the groom, and they came to her place, they came to her house, they visited her village, and they raped her in front of her husband. So again, a very brutal thing to do. So because she stopped the child marriage from happening, okay, so therefore she was brutally raped in front of her husband. So Banwari Devi's case received widespread attention and was symbolic of the challenges women faced in combating sexual harassment and violence, particularly when they were involved in efforts to challenge regressive social practices. So again, this is kind of a gender-based violence or gender discrimination. So a social worker who was taking such a step for the girl child, still she was raped because she was doing something against the society, is what the society felt, and therefore she was gang raped in front of her husband. So key points: lack of legal framework. At that time, India lacked a comprehensive legal framework to address sexual harassment at the workplace. This created a significant gap in the legal protection of women who experienced harassment in the professional lives. Okay, so there wasn't any kind of framework before this case for the protection of sexual harassment or harassment at workplace victims. Yeah, after that, public interest litigation was filed. A group of activists and organizations, including Vishakha, filed a PIL before the Supreme Court of India seeking guidelines and legal provisions to address sexual harassment at workplace. The petitioners argued that the absence of such laws and mechanisms was a violation of women's fundamental rights. A group of activists then, including Banwari Devi, was also a part of the group of activists, and Vishakha was also a part of group of activists, and they went to the Supreme Court and they filed a PILs for seeking guidelines and legal provisions to address sexual harassment at the workplace. So they didn't want it to face any kind of harassment while they were working, and therefore they went to the court. Okay. And they also said that it was a violation of women's fundamental rights. Okay, Supreme Court's ruling. So let us see what was the Supreme Court ruling in this case. The Supreme Court issued a historic judgment which was summarized as follows. It recognized that sexual harassment at the workplace is a violation of fundamental rights to equality and dignity under Article 14, 15, and 21 of the Indian Constitution. And the court acknowledged that there was an urgent need to create a safe working environment for women and to prevent and redress this sexual harassment. So even the court understood that there was a need at that time, even today, after that time, to create a safe working environment for women and to prevent and redress sexual harassment. In the absence of this legislation, the court provided a set of comprehensive guidelines to be followed by all the employers and institutions until the appropriate legislations were enacted. So, until the appropriate legislations were enacted, the Supreme Court of India set some few guidelines for the employers and institutions, okay, to create a safe working environment for women. So what were the guidelines? These are also called as Vishakha guidelines as provided by the Supreme Court. Included the following. First, definition of sexual harassment. It defined what was sexual harassment. A clear definition of what constitutes sexual harassment was provided, encompassing unwelcome advances, request for sexual favors, and other verbal or physical conduct of sexual nature. Okay, so the guideline included a clear definition for sexual harassment. Then the duties of employers. Employers were required to establish a mechanism to prevent and redress complaints of sexual harassment. This included the formation of ICC at the workplace. So after the Supreme Court's decision on this case, Vishakha guidelines were set, and one of the guidelines they also set the duties of the employers. What should be the duties of the employers? And through that, internal complaints committee was formed at workplaces where there were more than 10 employees working. Okay. Redressal procedures. The guidelines outlined a procedure for filing and redressing complaints, which ensured confidentiality and fair investigation process. Redressal procedure was also mentioned in the guidelines. Protection against retaliation. Protection for victims against any adverse action as a result of filing complaint was mandated. Again, so that the same thing doesn't happen to her from the same individual that harassed her. So there were some protection guidelines also set for this. Then awareness and training. Employers were directed to conduct awareness programs and training for the prevention and redressal of sexual harassment. Impact. So awareness and training guidelines were also mentioned. So what was the impact of the Vishakha case? The Vishakha case and its guidelines were instrumental in raising awareness about the workplace sexual harassment in India and led to significant changes. It eventually paved the way for the enactment of Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013. which provides a legal framework for addressing sexual harassment at workplace. The Act and the Vishakha guidelines remain essential tools in ensuring the safety and dignity of women in workplace. Let us just go through the legal provisions in India against workplace harassment. In short, so yeah, filing a complaint. A complaint of sexual harassment can be made by the aggrieved person. The victim has to file a complaint, or by any person authorized by her. So any person authorized by her in the name of her, that you on my behalf go and file a complaint, okay, against the harasser. Then section 10 says time limits. The act specifies that the complaint must be filed within 3 months. Remember this important point. The complaint must be filed within 3 months from the date of incident. From the date of incident, the complaint must be filed within 3 months. However, in the case of a reasonable delay, the ICC, that is the Internal Complaints Committee, may still inquire into the complaint. For any reasonable delay that you have answer for, that you have reason for, the ICC still may inquire into the case. Then section 11 specifies complaint procedure. The aggrieved person must submit a written complaint to the ICC or the LCC if the complaint is against the employer. Complaint should include the details of the incident and names of the person involved. So what must the complaint include? The complaint should include details of the incident, how the incident happened and what exactly happened, and the names of person involved, and who were the people involved into the harassment. Then section 12 specifies confidentiality. The Act emphasizes that the complaint procedure should be confidential and the identity of the complainant and the respondent should not be disclosed during the inquiry. So it also emphasizes that the complaint procedure should be confidential and the identity of the complainant must not be known and the respondent should not be known or disclosed during the inquiry. So ICC and LCC must take care of this, that the names are not disclosed. Again, section 13 specifies inquiry and resolution. The ICC or the LCC is responsible for conducting an inquiry into the complaint. The inquiry should be fair and impartial, ensuring that both the complainant and the respondent have an opportunity to present their side. Both the complainant and the respondent should have the opportunity to present their side. The ICC or the LCC shouldn't be biased, and the inquiry should be fair, impartial, and ensuring that both of them get to present their side of the story. Okay, then the section 14 specifies time frame for resolution. The ICC is expected to complete the inquiry and provide a report with their recommendation within 90 days. Again, so the ICC is expected to complete the inquiry and provide for a report within 90 days. Okay, within the 90 days of your complaint. The report should be shared with the complainant and the respondent. So you should get your report from the ICC within 90 days of the complaint that you've made. Legal provisions. So section 15 section 15 specifies action taken. Based on the inquiry, the ICC or the LCC has the authority to recommend appropriate actions against the respondent, including warning or suspension, or they can warn them, or they can suspend them from the job, or they can transfer them to some other place, or they can terminate, or termination of the contract between the employer and the employee. Okay, so ICC and LCC can take all of these actions against the harasser. And section 17 specifies that if either the complainant or the respondent is dissatisfied with the ICC's decision, then they have a right to appeal to the appellate authority. So even after this, if the complainant is not satisfied with the decision that ICC has made, then they still have a right to appeal to the appellate authority. Section 18 specifies a appellate authority. The appellate authority consists of the head of the organization or an authority higher than ICC. So, what is the appellate authority? It consists of the head of the organization. Either it can be a person who is the head of the whole organization or an authority that is higher than NCC. So, the authority has to be higher than NCC for appeal. So, if you still want to appeal, you have to go to someone who is either the head of the organization that you have been working in, or an authority that is higher than the ICC in your organization that you are working. The decision is considered final. The decision is considered final if you go to appeal, and if you appeal to the head of the organization or the authority that is higher than ICC. So their decision is considered to be the final decision. Section 21. Protection from retaliation. The Act prohibits any adverse action against a complainant for filing a complaint, and such actions are treated as misconduct. So again, the Act prohibits any adverse action against the complainant or filing a complaint. बहुत बार ऐसे होता है कि अगर if the harasser understands who has filed a complaint against him, तो बहुत बार ऐसे होता है जो हम लोग अभी देखते हैं, to try to murder the person, or acid attack के जो stories है. So many a times, even the complainant gets scared that if we tell or if we complain about this person, then he may do such things to me. So many a times they don't feel safe, and that is why the confidentiality has been mentioned into this that we saw in the previous slide. So again, so the court specifies in section 21,
Pulao, raita, butter chicken, liver masala.
Protection from retaliation. Please mute your mics, everyone, please. Yeah, the Act prohibits any adverse action against a complainant for filing the complaint, and such actions will be treated. And still, if the person does that, then such actions will be treated as misconducts, and further, the court may give any judgment against him. The civil and criminal remedies against workplace. So, what are the remedies for you? In India, workplace harassment is addressed under Sexual Harassment of Women at Workplace Act 2013. The Act provides for both civil and criminal remedies against workplace harassment. This punishment provisions for workplace harassment can vary depending on the severity of offenses and the outcome of the investigation. So here's just an overview. So administrative action. The internal or the local complaints committee can recommend administrative actions against the harasser, such as written apology. It may ask the harasser for a written apology, apologizing for the conduct that for his behavior or for his conduct, or they can warn the person, or they can suspend the person, or they can terminate the employment. Then we have got, this is the administrative action that ICC and LCC can take. We have got civil remedies. The victim may also seek civil remedies such as monetary compensation for the harm suffered. The victim may also receive a civil remedy for this, such as monetary compensation for the harm suffered. You may also get monetary compensation for the harm that you've gone through. The compensation may cover medical expenses, emotional distress, and loss of employment opportunities. If you have gone through any of this, that is, if you had medical expenses throughout this whole incident, or emotional distress that you have gone through, that you have suffered through, or a loss of employment opportunities due to the harassment, the amount of compensation is determined based on these facts. The court will decide that it will investigate into all of the facts, and then it will determine what the amount of compensation has to be. But you can claim the compensation if you're going through any of this. So criminal penalties. In severe cases, the harasser may face criminal charges under the Indian Penal Code. The specified section applicable is section 354A, which deals with sexual harassment and can lead to imprisonment for a term ranging from 1 to 3 years. So 1 से 3 साल की भी उनको punishment हो सकती है under the section 354A. ये criminal penalty है. तो ये भी हो सकता है, जितना अगर सीवियर मैटर रहेगा, सीवियर केस रहेगा, तो ये पनिशमेंट भी हो सकती है, रेंजिंग फ्रॉम 1 to 3 years. Violation of service rules. If the harasser is a government employee, the violation of service rules can lead to disciplinary action, including suspension or dismissal. So if the employee or if the harasser is a government employee, then he can either get suspended or he can be dismissed from his service. Okay. So now that we've gone through the remedies, by this we come to the end of the lecture. So what are the do's for the victim, for the workplace harassment victim? So first is to do report the harassment, report workplace harassment to the appropriate authority promptly. Second, do's is do document incidents. Keep a record of incidents, dates and witnesses, gather evidences. Okay. Third is to do seek support from HR, colleagues, or a counselor. So if you're going through any emotional distress, you can also seek support from your colleagues or from the HR, or you can go to a counselor as well. Do familiarize with policies, understand your workplace harassment policies and procedure. It's very important to, for all of us to know what are the policies, workplace harassment policies. Okay. And what is the procedure, and for that only we are taking all these lectures for 9 days, so that you understand your rights. Okay. So do prioritize self-care, take care of your mental health and emotional well-being. Okay. Take care. You can also see a therapist if you're going through some severe emotional distress. Now, what are the don'ts? Don't stay silent. Don't suffer in silence. Report harassment promptly. Okay, so don't stay silent. Don't suffer in silence. Report the harassment promptly. Don't retaliate. Avoid retaliatory actions. Let the proper channel handle it. Okay, don't retaliate. Even if you're facing this, don't retaliate. You give the complaint and let the proper channels handle it. Let them handle it. Let the ICC or the LCC or the court handle it. You yourself don't retaliate. Don't isolate yourself. Don't isolate. Seek support from trusted colleagues or friends. Don't isolate. Don't go alone. Don't violate policies. Avoid violating your workplace harassment policies. So don't violate any policies. So the harasser has a point against you that you've violated any policy. Okay. Don't ignore self-care. Don't neglect self-care. Seek professional help if needed. Seek therapy if needed, if you're going through any emotional distress. So don't do all of these things. Again, so now putting it all together. In conclusion, workplace harassment encompasses unwelcome behavior based on protected characteristics. Various types of harassment exist. We have seen the various forms of workplace harassment that exist, and victims should report incidents to the internal complaints, the local complaints committee, ensuring a time-bound confidential investigation while safeguarding against retaliation. You don't have to retaliate. We saw that in the don't section, we saw that you don't have to retaliate, and let the committees handle it. Let the right people handle it. Legal action may be pursued when needed. Okay. We'll just try to remember two things. When do you have to complain? Within the 3 months of the incident. Within the 3 months of the incident, you have to file a complaint. And to whom to file a complaint? Either to ICC, you've got this option, either to ICC. If ICC does not exist at your place, at the place you work, then to the LCC, local complaints committee, or you can take the help of court. You can approach the court directly, or you can file a complaint and FIR to the police station as well. Okay. So by this we come to the end of the lecture. So question of the day. So this is I purposely made this question so that all of us think over this issue. That is, are women's rights truly equal if they can't be exercised without fear? Like I told you earlier, that there are incidents of acid attacks or attempt to murder towards the victims if they complained about the harasser. So my question to all of you is, are women's rights truly equal, that we have been discussing for all these days now, for the 6 days? We have been discussing about the women's rights, and we'll also discuss about them further as well. But are women's rights truly equal? They can't be exercised without fear. This is the question that I think all of us, including women and men, must keep asking ourselves, and create a safe environment for the people around us. Okay, so by this we come to the end of the lecture. Sorry, excuse me. Thank you everyone for this session. Now we'll continue with another session. Give me a minute. I hope all of you all have understood. Just a minute. I hope all of you have understood yesterday's lecture that we took today. Are you able to see the screen? Is everyone able to see the screen?
Yes.
Okay, yeah. Okay, we'll continue with the second lecture. But before we start, I want to tell you something. Today's topic, that is legal aspects of marital relationship, is a very vast topic because marriage laws are involved. We are going to talk about divorce, maintenance, and child custody. But again, the marriage laws, the divorce provisions, the maintenance and child custody, again, not the maintenance and child custody, but the marriage laws and divorce, again, depends, are different for different religions. So for Hindus it's different, for Muslims it's different, for Christians, Parsis, so it's different. It's different, so that many of the religions have their own personal laws. Okay, so that is why today in this session the whole topic becomes very vast. So in this session we are going to talk about primarily about Hindu, but okay, we'll also see a little brief about the other religion personal laws as well. But primarily we are going to talk about Hindu marriage laws, divorce, maintenance, etc., and child custody. Just give me a second, please. Okay, so welcome again. Welcome all of you for this session today. Yeah, today is day 6. That symbolizes, today's the color of the day is green. That symbolizes sustainability, sustainable equality. Green represents sustainability, and we are committed to sustainable equality for women. We strive for a society where gender equality is not just a temporary trend, but a sustainable reality. Through our efforts, we aim to create a lasting impact by promoting equal opportunities and dismantling gender-based barriers. Okay, the aims and objectives. Again, through all these lectures and through all the webinars that we are going to conduct, what is our aim, or what is our objective, is to aspire to cultivate a society where women can thrive without being hindered by gender-based discrimination, and where both the genders enjoy fair and equal treatment. Our sessions are not against any gender. Okay, marriage laws in India. We'll start with marriage laws in India. So marriage laws in India are diverse and complex, as they are influenced by various personal laws, customs, and religions. The major marriage laws in India can be categorized based on religion and personal laws. Here is an overview. So first we'll learn about Hindu Marriage Act. I've put all the points in brief because this topic, like I said before, is quite huge. It's quite vast. So we'll discuss everything in brief. Okay, so Hindu Marriage Act 1955, whom is it applicable to? So it is applicable to Hindus, Buddhists, Jains, and Sikhs. Okay, so Hindu Marriage Act 1955 is applicable to Hindus, Buddhists, Jains, and Sikhs. It defines the conditions for valid Hindu marriage, including what must be the age, consent, what are the prohibited degrees of relationship and monogamy. It provides for registration of Hindu marriage. Also, it covers issues like divorce and maintenance. Okay, so this is all included in Hindu marriage. It is covered in the Hindu Marriage Act 1955. Then we have got Special Marriage Act. Special Marriage Act is specifically for intercaste or interreligion religious marriages. Okay, so if somebody has done intercaste or interreligious marriage, then they may have the support of Special Marriage Act. Okay, so applicable to all Indians irrespective of their religion. It is applicable to all Indians irrespective of their religion. Provides legal framework for interreligious and intercaste marriages. Okay, so this Special Marriage Act provides legal framework for interreligious and intercaste marriages, allows couples to marry without following the customary rites or rituals of their respective religions. So if there is some intercaste marriage or interreligious marriage, then the couples may marry without following the customary rituals or rites of their respective religion. Okay, through Special Marriage Act, requires a notice of intention to marry, a 30-day prior notice and registration. So before you get married, if you are an interreligious or intercaste marriage couple, then before you get married, you have to submit a 30-day a 30-day notice prior to the wedding date, a 30-day prior to your wedding date, and must be registered. Okay. Then we have got personal laws, Muslim personal law. Muslims in India are governed by their personal law, which includes Shariat Act. So Muslims are governed under the Shariat Act. Marriages among Muslims are solemnized as per Islamic laws. So marriages among Muslims are solemnized as per Islamic laws. Polygamy is permitted. All of us know Muslims can have 4 wives, subject to certain conditions. Okay, again, this is subject to certain conditions. Then we've got Christian marriage laws. Christians in India are governed by the personal laws. The Indian Christian Marriage Act 1872 regulates Christian marriages, including provisions for divorce. Okay, so Christian marriage are governed under the Indian Christian Marriage Act 1872. Then we've got Parsi Marriage and Divorce Act 1936, applicable to Parsis, that is Zoroastrians, regulates Parsi marriages and provides for divorce. Okay, we've got Jewish marriage laws. Jews in India are subject to personal laws, which include marriage and divorce. For dissolution of marriage, various marriage laws in India also address the dissolution of marriage, including divorce, annulment, and judicial separation. So various marriage laws only specify, they also have this provision for dissolution of marriage if the couple is willing to dissolve the marriage. Okay, so registration for marriage. Many states in India require the registration of marriages irrespective of the religion of the parties involved. Marriage registration provides legal recognition and documentation of the marital relationship. If you're getting married, you have to register the marriage, despite irrespective of the religion that you belong to. Okay, so Child Marriage Restraint Act 1929. This act is applicable to all the communities and seeks to prevent child marriages by setting a legal minimum age for marriage, that is 18 years for the girls and 21 years for the boys. Okay, it is applicable to all the communities, remember this point, and seeks to prevent child marriages. It's important to note that India has a diverse population, and personal laws are often determined by the individual's religion or community. The legal framework governing marriages in India can be quite complex, and it's advisable for individuals to consult with legal experts or local authorities to understand and adhere to the relevant laws and procedures when getting married. Okay, so in India, valid marriages are governed by various personal laws. We saw that apply to individual based on their religion. Okay, these laws specify the conditions that must be met before the marriage. Okay, so now we are going to study about the conditions that must be met before marriage to be legally recognized. The primary conditions for a valid marriage in India include. So these are the conditions for a valid marriage. So if you want your marriage to be valid, you must go through these conditions first. First is the age of marriage. Hindu Marriage Act specifies the minimum age of marriage is 18 years for the brides and 21 years for the grooms. Special Marriage Act also specifies the same thing. Minimum age of the marriage, 18 years for the bride and 21 years for the groom, for the males. Muslim personal law, the age of the marriage varies among Muslim communities, but again, even Muslim personal law also follows the general legal age, that is 18 for females and 21 for males. Okay, now second condition is consent. Both parties must be willingly and without any force or coercion consent to the marriage. Okay, so both the parties must be willingly, or they must be willing to get married to each other without any force or coercion, without any pressure on them. Okay. Then monogamy. Under most personal laws in India, a person can only be married to one spouse. Monogamy as in marrying only one person. Okay, at the time. Bigamy or polygamy. Bigamy is having two wives or two spouses, two partners, or polygamy as in having multiple partners, that is more. Okay. Prohibited degrees. Marriages between close blood relatives and are generally prohibited. So marriages between close blood relatives. So your partner shouldn't be one of your close blood relatives. Such marriages are generally prohibited. The specific degrees of prohibited relationship may vary depending on the personal law of the parties involved. Okay. Again, the specific prohibition degrees of prohibited relationship, again, they may vary depending on the personal laws of the parties involved. Okay. Mental capacity. Both the parties must have mental capacity to understand the nature of the marriage and the responsibilities that come with it. So both the parties, okay, the bride and the groom, must have the mental capacity to understand the nature of the marriage. They must know what we are going through and what responsibility will come with the marriage. Okay, then the sixth condition is absence of subsisting marriage. If either party is already married and their previous marriage is subsisting, they cannot enter into another marriage. So if either of the party, either of the bride or groom is already married, okay, and has a previous marriage subsisting and is not divorced to that person and is already married, so they cannot enter into another marriage. They are not allowed to enter another marriage because we practice monogamy. Usually many of the religions practice monogamy. That is why they are not allowed to enter into another marriage if one marriage already exists. So no prohibited relationships. Parties must not be closely related by blood or adoption in any matter that makes the marriage illegal. Parties must not be closely related by blood or adoption in a manner that makes marriage illegal. Okay. So if that is the case, marriage may be illegal. Registration. Well, registration of the marriages is not mandatory in all the states. It is advisable to register the marriage to establish legal proof of marriage. So if you want to establish a legal proof of the marriage, so that tomorrow, in any cases, in any consequences, you don't face any challenges. So it is advisable to register the marriage, okay, for a legal proof. Many states in India have made marriage registration compulsory. So many states in India have made marriage registration compulsory. It is important to note that India has diverse personal laws for different religious communities, for example, Hindus, Muslims, Christians, Sikhs, etc. And the conditions for a valid marriage can vary. Again, the conditions for a valid marriage can vary among these communities. Additionally, the Special Marriage Act allows the people from different religious backgrounds to marry under a secular law, which has its own set of conditions. Okay. Again, like we learned about the Special Marriage Act, it allows people from different religious backgrounds to marry under a secular law, which has its own set of conditions. Okay, they also have their own set of conditions. Now, what is restitution of conjugal rights? So, restitution of conjugal rights is a legal remedy available to certain personal laws in India, including Section 9 of Hindu Marriage Act 1955 and Section 22 of Special Marriage Act 1954. This remedy is designed to encourage spouses who have separated or deserted each other to return into the marital home and live together as a husband and wife. Here's an explanation on the restitution of conjugal rights. So, what are restitution of conjugal rights? So, any of your partner, either the husband or the wife, for any reason has deserted or does not has separated without any reason and is not staying with you, even if the marriage is still present and there hasn't been any dissolution of marriage, then you can apply for restitution of conjugal rights. You can request the partner to come back through the court. Okay, so what is the definition? Restitution of conjugal rights is a legal action through which okay, through which one spouse asks the court to order the other spouse to return to the matrimonial home, fulfill their marital obligations. So if you're still in the marriage and if you don't stay with your partner, or for some reason you have separated and left the house, so the other partner can go to the court and ask the court to order the other partner to return back to their matrimonial home and to fulfill the marital obligations. Okay, this is known as restitution of conjugal rights. Conditions for filing a restitution of conjugal rights petition. To file a restitution of, okay, I'm extremely sorry. Is my okay.
Screen has gone.
Yes, yes.
Slide
Keshav,
screen.
not able to share my screen, sir.
Okay, 1 second.
Okay, thank you, sir. Now I'm able to share. Is everyone able to see the screen?
Yes.
Yes.
Okay. Yeah. So restitution of conjugal rights. So we saw the definition. So now, what are the conditions for filing a restitution of conjugal rights petition? To file a restitution of conjugal rights petition, the following conditions generally must be met. The spouses must be legally married. So the first condition is that the spouses must be legally married. Okay. One spouse has either withdrawn from the society or of the other without reasonable causes, or has refused to cohabit with the other. So one spouse has either withdrawn from the society, is not staying with the partner, and there isn't any specific reasonable cause for why the partner is behaving like that or not staying with the other partner, or refused to cohabit together, or is refusing to stay together again. So the petitioner, this is your second condition. If this is the reason, okay, if this happens, then the third condition is the petitioner, the spouse seeking restitution, must not be at fault for the separation or refusal to cohabit. So the spouse who is seeking for restitution, who wants the court, or who is requesting the court to order for against the other spouse to come and again start the and fulfill the marital obligations. So that person who is trying to seek the restitution must not be at fault, okay, for the separation and or refusal to cohabit. So that person who is seeking restitution must not be at fault himself. Just a minute. Okay. Now, what are the key points of restitution of conjugal rights? The spouse seeking restitution must prove that they are ready and willing to resume marital relations and cohabitation. This means that they must be genuinely interested in re-establishing the marital relationship. So the spouse who is seeking restitution, who wants restitution, and who wants the court to order the other person to come and stay together again, So they must be genuinely interested in re-establishing the marital relationship. Okay. The remedy of restitution of conjugal rights is not a punitive measure, but rather a legal tool to encourage reconciliation. Okay, it's not punishment, it's not a punitive measure, but rather a legal tool to encourage reconciliation. Okay, if the court grants a decree for restitution of conjugal rights, it is not an order for forced cohabitation. So it is not an order for forced cohabitation. It is primarily a declaration of parties' legal obligation. You know, it is primarily a declaration of parties' legal obligations, and it is left to the parties' discretion whether they wish to return or to the marital home. So basically, court court does not force anybody to cohabit together. If the spouse, if the other person, if the spouse is not interested in coming back or interested in staying together again, then the court cannot force. It is not forcing any cohabitation. वो बस एक प्रस्ताव सामने रख रहा है दूसरी पार्टी की तरफ से कि the other party wants you to come back. Okay. So this is the thing, and it is left to the party's discretion whether they wish to return to the marital home. Well, it depends on the other party whether they want to come or they don't want to come. Court cannot force. Okay. The court can also provide for restitution orders such as regular visits, counseling, or other measures. So the court can provide such orders whether the other person is allowed for regular visit, or counseling can happen, or any other measures can be taken by court to facilitate reconciliation. So the court can take these steps so that both of them come together again. Okay. Failure to comply with a restitution decree can be used as evidence in subsequent divorce proceedings. So the failure to comply with the restitution decree, if the restitution decree is already passed and there is a failure to comply, the person is not complying with it, can be used as an evidence in subsequent divorce proceedings. So even after restitution of conjugal rights, okay, the person is not complying with the restitution decree passed by the court, then it can be used as an evidence subsequent to divorce proceedings. So usually restitution of conjugal rights happen before the divorce directly. Many of the people can apply for restitution of conjugal rights before taking divorce. And reconciliation can happen during these times as well. And even if it doesn't, then we have a provision for divorce. So what is divorce? Divorce in India is a legal termination of marriage. Termination means the end of marriage union or marriage between husband and wife. So it's the legal termination, means officially you are separating from the marriage, okay, between a husband and a wife. It is a formal dissolution of a marriage that allows both the parties to go their separate ways and live independently. So what it is a formal dissolution, it is official dissolution of the marriage, and it allows both the parties to go their separate ways and live independently. They can now, after the divorce, can live independently. Divorce is governed by specific laws in India, and the procedures and grounds for divorce vary based on the personal laws. Again, the procedures and the grounds for divorce vary based on the personal laws applicable to different religious communities. Okay. Now let us see the provisions for divorce in India. Divorce provisions in India are governed by various personal laws that differ based on an individual's religion or community. The key provisions for divorce in India are, okay, now let's just have a brief idea of what the key provisions for divorce in India are. The first is Hindu Marriage Act 1955. Okay. So who comes under the Hindu Marriage Act? That is the Hindus, Jains, Buddhists, and Sikhs. Okay, so they can file for the divorce through Hindu Marriage Act, and the grounds for all of them, for all these religions that come under Hindu Marriage Act should be, so under the Hindu Marriage Act, a Hindu marriage can be dissolved on several grounds, including adultery, cruelty, desertion, conversion to another religion, So if there is adultery being performed by one of the spouses, or there is cruelty against one of the spouses in the marriage, or desertion, that means they're not staying together, or conversion to another religion, or if one of the spouses convert to some other religion, or there is some mental disorder in one of the spouses, or one of the spouses is going through an incurable disease, then there so then these are the grounds that the other spouse in the marriage can apply for the divorce on the basis of these grounds. Okay, there is also a provision for no fault divorce by mutual consent, where both the spouses agree to divorce. So again, there is a divorce by mutual consent as well, where both the parties want to take a divorce. Okay, so that provision is also there. Special Marriage Act 1954. This act provides provisions for divorce for marriages registered under it, which includes interreligious marriages, intercaste marriages. So if there's a couple who has married in some other religion, or there is a couple of intercaste marriage, so they can seek divorce through Special Marriage Act. The grounds for divorce are similar to those of Hindu Marriage Act. So even in the case of Special Marriage Act, the grounds for divorce that we've seen about, that is adultery, cruelty, desertion, conversion to another religion, mental disorder, or an incurable disease. So these are the grounds for a Special Marriage Act as well. And okay, so yeah. So next is the Muslim personal law. In Islamic law, the Muslim husband can unilaterally divorce his wife by pronouncing talaq, talaq, talaq 3 times in succession. Okay, reform efforts have been made to regulate triple talaq, and on 30th July 2019, the Parliament of India declared the practice of triple talaq illegal and unconstitutional, and made it an punishable act from 1st of August 2019. Okay, so Christian marriage laws. The Indian Divorce Act 1869 governs the Christian marriages. So Christian couple can go through divorce through the Indian Divorce Act 1869. It provides for divorce on the grounds of adultery, cruelty, and desertion. So here are only 3 grounds in the Christian marriage laws. That is, you can either seek divorce through adultery, okay, through the ground of adultery, or through cruelty, or through desertion, that is not staying together. Parsi Marriage and Divorce Act 1936. This act governs Parsi marriages and divorce. It allows the divorce on grounds similar to those under the Hindu Marriage Act. So even in Parsi Marriage and Divorce Act, the grounds for divorce are similar to the ones that we've seen in the Hindu Marriage Act. Other minority marriages among other religious minorities in India are governed by their respective personal laws. The provisions for divorce can vary among these communities. Again, the provisions of divorce can vary among these communities. Okay, provisions for divorce in India. So now let us see what are the provisions for divorce in India. So first is judicial separation. We'll just see what is judicial separation. Okay, so here are few provisions: judicial separation, or annulment, or child custody. Okay, so child custody and alimony, we are going to discuss on this topic in detail further. Okay, in addition to divorce, Indian marriage laws provide for judicial separation, which allows spouses to live separately without formally ending the marriage. Annulment is another legal remedy to declare a marriage null and void, as if it never existed. So we'll just learn about them in detail further. Child custody and alimony. In divorce cases, courts may also address issues related to child custody, visitation rights, and alimony, financial support to the spouses. So it is essential to consult with a legal expert or family lawyer when seeking a divorce in India to understand the specific provisions and procedures that apply to your situation. Okay, now let us see grounds of divorce under the Hindu Marriage Act. So certainly, here are the conditions and grounds for divorce in Hindu Marriage Act. In a Hindu marriage, under the Hindu Marriage Act, along with relevant sections. Okay, let us see what are the grounds in a little bit in detail. Grounds of divorce in a contested divorce. What is a contested divorce? Where only one party seeks divorce, where only one party wants a divorce, okay, from the other person. And then the other option is where you can have a divorce on mutual consent, where both the parties want to get divorced. So now first we'll go through the grounds for divorce in a contested divorce, that is where only one party seeks divorce. So first ground is adultery, that is section 13(1)(I) of the Hindu Marriage Act. So if a spouse engages in sexual relation outside of the marriage, so the other person, the other partner, the other party can file for divorce on this ground, on the ground of adultery, if his or her partner is engaging into adultery with some other person, okay, is having sexual relationships with some other person. Then the other ground is cruelty. Okay, the spouse seeking divorce must prove that the other spouse has treated them with cruelty both mentally and physically. So the one seeking divorce under this ground, that is cruelty, must prove that the other spouse has treated them with cruelty either mentally or physically or both. Okay. Then the third is desertion. If a spouse has abandoned the other spouse without reasonable causes for a continuous period of at least 2 years. So sorry, desertion, I said they were living separately, but it is actually if one of them has abandoned the other person for more than 2 years. Okay, if one of the party has abandoned his spouse, his or her spouse for more than 2 years, then the other person, that is the other party, can seek for divorce on the ground of desertion. Then there's conversion. If a spouse converts to another religion, so this is also one of the grounds. Okay. Then there is mental disorder. If a spouse has been incurably of unsound mind or has been suffering continuously or intermittently from a mental disorder. So one of the spouses, if they are going through some mental disorder or whatever disorder, mental disorder that they're going through is incurable, or if the person is of unsound mind, okay, so the other party can file for a divorce on this ground of, okay, on this ground to such an extent that the petitioner cannot reasonably be expected to live with the respondent. So the extent must be that the petitioner cannot reasonably be expected to live with such a person with a mental disorder. So then the party can file for a divorce on this ground. Then if the partner has a communicable disease, so this is also one of the grounds. If a spouse is suffering from a virulent, that means a disease that is spread through virus, and incurable form of leprosy. Leprosy is again a disease, or has other such communicable disease in a communicable form. Okay, yeah. So if one of the partners is going through any communicable disease, then the other spouse may file for divorce on this ground. Okay. Renunciation of the world. If a spouse has renounced the world by entering a religious order, okay, many people renounce their families. There are few people who renounce their families. They renounce the world as well. Okay. So if one of the partners has done this, then the other partner can seek divorce through this ground. Okay, not heard of being alive. Okay, so this is also one of the grounds for divorce. So if one of the spouse has not been heard of being alive for a period of 7 years or more, so if one of the partner disappears or goes somewhere and is not heard of being alive, but there is no news about such person for a period of 7 years or more, then the other person, that is the other spouse, can apply for divorce, can file for divorce through this ground. Okay, grounds for divorce in mutual consent divorce, where both the parties agree to divorce. Now let us see grounds for divorce in mutual consent. In a mutual consent divorce, the parties can file for divorce if they have been living separately for a period of at least 1 year. So if you want divorce with mutual consent, the parties, both the parties must be living separately for a period of at least 1 year, okay, and have mutually agreed to end the marriage, and both of them must have mutually agreed to end the marriage. The 1 year separation period may vary depending on the local laws, okay. The 1 year separation period may vary depending upon the local laws. Please note that these sections are a part of Hindu Marriage Act and serve as the legal basis for divorce proceedings in Hindu marriages. So now the ground that we have seen, are for the grounds of divorce under the Hindu Marriage Act, okay, and applies to only Hindus, Buddhists, Sikhs, Jains, and couples under the Special Marriage Act that we saw also for Parsi people, okay, for Parsi couple. Legal procedures may vary depending on the local laws and the specific circumstances of the case. So it is advisable to consult a family lawyer for guidance. Okay. So now, what is the procedure for divorce in India? The divorce procedure in India can be complex and lengthy process. Okay, and it is governed by various personal laws depending on one's religion and the specific circumstances of the case. So here is just a general overview of what the procedure of divorce procedure, what in India, what does it look like? Okay, so the grounds for divorce. First, it is essential to establish valid grounds for divorce. Okay, so it is very essential to establish valid grounds. Why are you applying for divorce, and what are the grounds under which you want to apply for divorce? The grounds vary depending on the personal law applicable to the parties involved, but common grounds include adultery. So the grounds also may vary, but the common grounds for seeking divorce includes adultery, that is having sexual relationship with some other person other than your spouse, or cruelty, conducting cruelty with your partner, or desertion. You all have not been staying together, or the person, one of your spouses, has abandoned the other spouse for more than 2 years, okay, or one of the spouses is going through mental illness and incompatibility. If one of the spouses is incompatible, then the procedure again is consultation with the lawyer. You must first consult a lawyer who specializes in divorce cases, okay. Then filing a divorce petition. So first you must file a divorce petition. The spouse seeking for divorce must file a divorce petition in the appropriate family court, okay. The spouse seeking divorce must file for divorce petition in the appropriate family court. The petition should include grounds. Okay, now first you have to seek what are the it is very essential to establish on what grounds you want divorce. Okay, on grounds for divorce and relevant details about the marriage and children involved. Okay, so the petition that you are filing should include the grounds for divorce and what is relevant details about the marriage. You must also put relevant details of the marriage and of the children that are involved through this marriage. Okay, then service of notice. After filing the divorce petition, the court will issue a notice to the other spouse, the respondent, to respond to the petition within the specified period. Okay, the respondent has the right to contest the divorce. So after filing the divorce petition, the court will issue a notice to the other spouse against whom the divorce has been sought to respond to the petition within the specific period. So the respondent has to respond to the petition within a specific period assigned to him. Okay. The respondent has also the right to contest the divorce. Response and counterclaim. The respondent can either agree to the divorce, uncontested divorce, that is without mutual consent, or to uncontested divorce as in with mutual consent, or to contest it. If the respondent contests the divorce, they can file a counterclaim, okay, outlining their objections and claims. So if the other party doesn't, or the respondent doesn't want the divorce to happen, so they can file a counterclaim outlining the objections and claims. okay, against the party, against the seeker of divorce. Evidence and examination. The court will conduct hearings and examine evidence provided by both the parties. So the court will conduct hearing and the court will examine the evidence provided by both the parties. Witnesses may be called to testify, okay, and the documents may be submitted to support the case. Both the parties can submit some documents to support the case. Then the mediation, the next step, that is the mediation or settlement will happen. Some courts may encourage mediation to help the parties reach an amicable settlement. If both the parties agree, to the mediation, a settlement agreement can be submitted to the court. Okay. Then decree nisi and decree absolute. If the court is specified, I'm extremely sorry, there's some construction happening near my place, so there might be this. But please bear with them. Please mute your phone. Please mute your phone. Okay, yeah. So decree nisi and decree absolute. If the court is satisfied with the grounds for divorce and the evidence is presented, it may grant a decree nisi for which is a provisional decree for divorce. After the waiting period, if there are no appeals, the court issues a decree absolute, making the divorce final. So if the court is satisfied with the grounds of divorce, the grounds that you provided to the court, and the evidence that are presented, see, after all of this, if the court is satisfied, okay, that the divorce must happen, it may grant a decree nisi, which is a provisional decree for divorce. It will grant a decree nisi, which is a provisional decree for divorce, and it will give you some time. Usually this time is of 6 months. It will give you a time of 6 months, a period of 6 months, and reconciliation efforts will be taken, and we'll ask you all to stay together, if possible. And so if possible, to reconcile the marriage, it will give you a waiting period of 6 months. Okay, so the court also doesn't want to break the marriages, and therefore this decree will be passed first. And even after 6 months, you all are not ready to reconcile. If the couple is not ready to reconcile, then, and if there are no appeals, okay, the court issues a decree absolute, which is making the divorce final. Okay, even after a waiting period, you are not ready to get back together or to reconcile, then the court issues a final decree absolute, making the divorce final. Okay, then let us talk about the child custody and alimony. Issues related to child custody, visitation, and alimony, that is the maintenance, may be addressed during the divorce proceedings. So these issues will be addressed during the divorce proceedings. Court will consider the best interest of the child and the financial circumstances of the parties. So actually, court will actually go through the financial circumstances, okay, of the party which is going to pay the maintenance, which is going to pay the alimony, okay, and will also consider the best interest of the child, okay, of the child, to give custody to which person to give custody, okay. So the court will decide all of these things in the divorce proceedings. Appeal. Either party has the right to appeal to the court's decision. So either party, both the parties have the right. Any one of them has the right. Both the parties have the right to appeal to the court's decision if they are dissatisfied with the judgment. Okay. If any one of them is dissatisfied with the judgment, they may appeal. They have the right to appeal. Registration of divorce. Once the divorce is finalized, it is advisable to obtain a divorce decree certificate, which can be used to update legal documents and records. So once if the divorce is finalized, it is advisable to obtain a divorce decree certificate, which can be used to update legal documents and records. Okay, so you will officially have a record that you have been divorced. Okay, so it's crucial to note that the divorce procedures can vary significantly depending on the personal laws governing the marriage. For example, divorce procedures of Hindus, Muslims, Christians, and Parsis may differ. Okay, consultation with the knowledgeable family law attorney is essential. What is judicial separation? Okay, now we'll see what is judicial separation. So before this, we saw 3 types of dissolution of marriage, and one of them was divorce. Second is judicial separation, and third is annulment. Now that we've discussed upon divorce, now we'll see what is judicial separation. Okay, so what is judicial separation? Judicial separation is a legal process through which a married couple can formalize their decision to live separately without officially ending their marriage. It allows the spouses to maintain their legal marital status while living apart. So what is judicial separation? Judicial separation is a legal process, okay, through which married couple can formalize their decision to live separately. Okay, if the married couple decides that we will stay in the marriage, we are not officially getting divorced, but we also don't want to stay together. Okay, we will stay separately without ending the marriage. It allows the spouses to maintain their legal marital status while living apart. So they can stay apart, they can stay separate, but still be married to each other, okay, without any official divorce. So this is judicial separation. Purpose: some couples may choose judicial separation for various reasons. Okay, some couples also choose judicial separation instead of divorce, such as the hope of reconciliation. If one of them wants to reconcile, okay, in future, or to protect their legal rights like inheritance or property claims. Many times inheritance or property claims are also a part of the marriage. So if one of the parties or is they may choose for judicial separation instead of divorce. So to reconcile, to be on a hope that someday the reconciliation may happen. So what are the grounds for judicial separation? In many legal systems, the grounds for judicial separation are similar to those for divorce. Okay, in many legal systems, the ground for judicial separation are usually similar to the divorce. These grounds can include adultery, cruelty, desertion, mental illness, or other factors that make it impossible for the couple to live together. Okay, usually the grounds are these only: adultery, cruelty, desertion, mental illness, or other factors that make it impossible for the couple to live together. Okay, rights and obligations. Even though the couple lives apart, the legal obligations of marriage, such as spousal support and inheritance rights, may still apply. Even if they are staying separate, but they are still married. Okay, so the legal obligations of marriage, such as spousal support and inheritance rights, may still apply. However, the couple's financial and property affairs can be legally separated. Okay, however, couples financially and property related affairs can be legally separated. Conversion to divorce. In some legal systems, judicial separation can later be converted into divorce if the couple decides to end their marriage. Just give me a second, please. Yeah. So what is the next step? So let's move further. Okay. So now that we've discussed judicial separation, let's discuss annulment. What is annulment? Definition. Annulment is a legal process that declares marriage null and void. Okay, as if it never existed. Okay, it is not the same as divorce or separation, as it erases the legal existence of marriage. Okay, what is annulment? It declares the marriage null and void. Okay, as if it never existed only. The marriage was null and void since the start. It is not the same as divorce. It is not the same as divorce or separation, as it erases the whole legal existence of marriage itself. For example, if I may tell you, okay, so in Hindu law, so Hindu Marriage Act does not specify bigamy or polygamy. So if one person tries to marries two people, if a person marries two people and only monogamy is allowed, that means having only one spouse is allowed in the Hindu Special Marriage Act, then automatically the second marriage will become null and void. Okay, the whole legal existence of that marriage will become null and void, and this is called annulment. purpose. Annulment is typically sought when there is a fundamental defect or a problem with the marriage itself. Or see, these are also grounds. One of them, like I told you, bigamy. Okay, it is often based on grounds like bigamy. If a person commits to some other marriage, gets married to another spouse, to another person while having his own spouse, while already being in one marriage, then this can be a ground for the annulment of the second marriage. That means the second marriage will be null and void since the start, and the legal existence of marriage won't be there. Okay, so bigamy is one of the grounds. Consanguinity, marriage between close blood relatives. Like we saw, marriage between close blood relatives is illegal, and still a person gets married to close blood relatives, then the marriage itself will be null and void. It will be illegal. Importance, fraud, importance as in if one of the partners is important or has committed fraud, has fraudulently got the other person into the marriage, or a lack of mental capacity to consent to marriage. If the person lacks in the mental capacity to consent, to give that person's consent to the marriage, and and if the marriage has happened through all of these, on any of these grounds, then the court may grant annulment. Okay, that means the marriage never existed. The marriage is legal and illegal and void, null and void. So what is the effect when marriage is annulled? It is considered to have never existed in the eyes of law. This means that the legal rights and responsibilities that arise from marriage do not apply. Okay, that means the legal rights and responsibilities that arise from such a marriage that has already been null and void. So the legal rights and responsibilities arise from such a marriage, they do not apply at all. Children born of annulled marriage are usually considered legitimate. So even if the marriage is considered as null and void and illegitimate, null and void, and the legal existence is not there, still the children that are born through such marriages. So if a person commits bigamy and marries another person while already being married to one spouse and having a spouse, and if through his second marriage, if the person has children, then those children will be considered as legitimate. Okay, legitimate as in they will have legal rights. Okay, even if the wife does not have, or even if the marriage won't have, but those children from the second marriage may have will have legal rights, and they will be considered as legitimate children. That means the children from a legal marriage, the rights that children have from legal marriage, the children that are through illegitimate the children that are from an illegitimate marriage will also get equal rights like the children that are from a legitimate marriage. Okay, then timing. Annulment must generally be sought relatively soon after the marriage takes place and before the couple has had common life or children together. So probably this should be done before the couple has children together. The time limits can vary by jurisdiction. Okay, the time limits can vary. Grounds and procedures. The grounds and procedure for obtaining an annulment can differ significantly depending on the legal systems and the specific circumstances of the case. In summary, the judicial separation is a legal arrangement that allows a married couple to live apart without ending the marriage. Okay, whereas annulment is a legal process that declares the marriage null and void. Okay, I hope you have understood the difference between judicial separation, annulment, and divorce. So what are the maintenance provisions? Now let's come to the maintenance provisions. Maintenance provisions in India regarding divorce are designed to provide financial support to spouses, particularly the economically disadvantaged spouse, during and after divorce proceedings. The maintenance awarded may be temporary, interim maintenance, or permanent alimony. Okay, so these provisions can vary based on personal laws, individual circumstances, and the discretion of the court. Here's an overview of maintenance provisions related to the divorce in India. Okay. So what are maintenance provisions in India regarding divorce? Are designed. How are maintenance provisions designed? They're designed to provide financial support to the spouse who is particularly economically disadvantaged. Okay. Who does not have a source of income. Okay. So for them, maintenance provisions can be granted through the court. So first is interim maintenance. Let us understand what is interim maintenance. Interim maintenance, also known as pedente light maintenance, is a financial support provided to one spouse during the pendency of the divorce case. Okay, while the divorce case is going on in the court, and as we know that divorce, like the cases once went in the court, can take some amount of time, and that may amount to years as well. So whatever expenses that have been made during such a procedure, so if one of the person is not able to make such expenses for herself or himself, then the court may grant interim maintenance. Okay, if one of them is requiring financial support, okay, and is not able to make to the expenses of the divorce procedure, okay, of the court procedure. The amount and duration of interim maintenance are determined by the court based on the factors such as income, financial needs of both the spouses, and the standard of living. The amount and duration of interim maintenance are determined by the court. Okay, so all the amount, how much amount to give as maintenance, and the duration, for how much amount of time you need to give this maintenance. Okay, in interim maintenance, all these factors, with going through all these factors, the court will determine how much should be given, such as income and financial needs of both spouses and the standard of living. Considering all of these factors, the court will grant interim maintenance. Interim maintenance is meant to cover daily expenses and maintenance and maintain the status quo of the divorce proceedings. I'd like to mention here, recently there was this Delhi High Court. Just give me a second. Delhi High Court recently, just a second. Yeah. Just a second. Yeah, so Delhi High Court recently in this month, a few days ago, declared that no interim maintenance to wife under Section 24 Hindu Marriage Act, where both spouses qualified and earning equally. So no interim maintenance should be given if both the spouses are earning equally, are equally qualified, and if both the spouses are earning equally, and one of them who wanted to seek maintenance is also earning quite to maintain a good standard of living. So maintenance in such cases will not be given. Okay. Then we've got permanent alimony. Permanent alimony is a long-term or ongoing financial support awarded to the spouse after the divorce is finalized. Okay. So after the divorce is finalized, permanent alimony can be granted, okay, to the spouse seeking divorce or to the spouse seeking maintenance. The purpose of permanent alimony is to ensure that the economically disadvantaged spouse can maintain a similar standard of living post-divorce. So the purpose of permanent alimony is to ensure that the economically disadvantaged spouse can maintain a similar standard of living post-divorce. So बहुत बार ऐसे होता है कि जो वाइफ है उनके पास खुद का कुछ साधन नहीं होता to maintain herself. So in such cases the spouse may ask for maintenance. Okay, the court considers various factors including the financial resources and needs of both spouses, the duration of marriage and the relevant circumstances. तो बहुत फैक्टर्स देखता है कोर्ट और उसके बाद डिसाइड करता है कि परमानेंट भी जो एलिमनी होगा, मतलब परमानेंटली जो दूसरे पार्टनर को देना पड़ेगा, तो वो क्या होना चाहिए, ये सब कोर्ट सोच समझ कर सब फैक्टर्स देख के ये डिसीजन लेता है. ओके, अंडर वेरियस पर्सनल लॉज, maintenance provisions can differ significantly based on personal laws. Okay, so maintenance provisions can differ significantly based on personal laws. Under the Hindu Marriage Act, the Hindus, both spouses have the right to seek maintenance during the divorce, and the court considers factors like spouse's income, property, conduct. जैसे मैंने अभी बोला, ये सब फैक्टर्स देखता है कोर्ट की. इनकम कितना है, उसके पास प्रॉपर्टी कितना है, उसका कंडक्ट क्या है. तो ये सब देखने के बाद कोर्ट डिसाइड करता है कि कितना मेंटेनेंस देना चाहिए. ओके, सो सिमिलरली अदर पर्सनल लॉज सच एज द मुस्लिम वुमेन प्रोटेक्शन ऑफ राइट्स और डिवोर्स एक्ट in 1986 and the Christian Marriage Act 1872 provided for maintenance to women after divorce. Okay, enforcement of maintenance orders. तो मैं थोड़ा सा अभी इसके बाद, क्योंकि काफी लेक्चर बड़ा हो जाएगा, काफी लोग बोर भी हो सकते हैं, many have already left, तो थोड़ा सा मैं अभी ब्रीफ में ही समझाऊंगी. ओके, so enforcement of maintenance orders. Enforcement methods can include wage garnishment, seizure of property, or other actions. So what is wage garnishment? Okay, so a wage garnishment is a court order or official notice directing a third party to collect funds. See, if one of the party is not giving, even after maintenance orders, is not giving the funds to the other party, then the court may appoint a third party to collect such funds and give to the other party. Okay, so the defendant to fulfill certain financial obligations or debts such as child support, student loans, tax levies, etc. The third party जिम्मेदारी देता है to collect funds from a defendant to fulfill certain financial obligations. I'm extremely sorry. I think there might be some network issues. Okay, so wage garnishment हमने देखा. Seizure of property, अगर property है और वो फिर भी उसके और उसके अगेंस्ट मेंटेनेंस ऑर्डर्स है, फिर भी वो फुलफिल नहीं कर रहा है, तो प्रॉपर्टी को सीज किया जा सकता है. ओके, और अदर एक्शंस में बी टेकन, जो भी कोर्ट, whatever court thinks fit. Okay, in the case, so court may take those actions. So maintenance, again, maintenance provisions for various personal law. So under Christian maintenance provision, under the Divorce Act, Indian Divorce Act 1869, alimony pedente light, that is till the final judgment is given, this section allows the wife to claim alimony during divorce proceedings. Okay, alimony मतलब जो permanent settlement है जो हमने देखा. Okay, interim maintenance नहीं, interim maintenance is until the divorce proceedings are going on in the court. Alimony is permanent settlement. So under the Christian maintenance provisions, alimony pedente light, this section allows the wife to claim alimony also, like permanent settlement also, during the divorce proceedings, even if the divorce proceedings are going on. So in Christian for Christian couple, this may also be there. Section 38, permanent alimony and maintenance. This section provides award of permanent alimony and maintenance to the wife after divorce. So Parsi maintenance provisions is the provision for maintenance. This section allows the court, section 37, to order maintenance for a divorced wife based on various factors. Okay, Sikh maintenance provisions. For Sikhs, there is no specific personal law that governs marriage and divorce. In such cases, the relevant provisions of the Indian Divorce Act or the Special Marriage Act may apply. Intercommunity marriages, permanent, like the Special Marriage Act, permanent alimony and maintenance. This section allows the court to order permanent alimony and maintenance for their wife after divorce. Okay, who can claim maintenance? A wife can claim maintenance from the husband. Okay, divorced or separated wives can claim maintenance. Okay, divorced and separated wives can claim maintenance from their former husbands under the relevant personal laws, including Hindu Marriage Act, Muslim Personal Law, and Christian Marriage Act. Abandoned spouse, okay, in cases of where the spouse has been abandoned by the partner without reasonable cause, may be entitled to claim maintenance. Women after talaq or divorce, okay, can be or have obtained a खुला, तो खुला नामा होता है, क्योंकि हमने मुस्लिम लॉ इतना डिटेल में नहीं किया, तो I'll just mention खुला, may be entitled to maintenance during the iddat. Iddat period is actually the waiting period of 3 months after divorce. Okay, so during this time, Muslim women can also can claim the maintenance. Mentally ill or deserted spouse. A spouse suffering from mental disorder or who has been deserted may be entitled to maintenance under such circumstances. Okay. Domestic violence victims. Victims of domestic violence, including wives and children, can claim maintenance under the Protection of Women and Domestic Violence Act 2005. जो सेकेंड लेक्चर था हमारा, उसमें हमने डोमेस्टिक वायलेंस इन डिटेल में पढ़ा, तो उसके जो विक्टिम्स हैं वो भी मेंटेनेंस क्लेम कर सकते हैं. ओके, मूविंग ऑन. Custody of the child. This is our last topic. Please stay together. In India, the custody of child during and after the divorce is determined based on the principle of the best interest of children. Okay. So what will the court see? The first thing that court will see is the best interest of the child. Okay. The paramount consideration in any child custody in India is the welfare and best interest of the child. तो चाइल्ड का बेस्ट इंटरेस्ट किसमें है, माता के साथ रहने में है या पिता के साथ रहने में है, ये कोर्ट पूरा कंसिडर करेगा. ठीक है. द कोर्ट एम्स टू इंश्योर दैट द चाइल्ड्स फिजिकल, इमोशनल एंड इमोशनल नीड्स, एजुकेशनल नीड्स आर मेट एंड दैट देयर ओवरऑल वेलबीइंग इज प्रोटेक्टेड. ये देखने के बाद ही कोर्ट कस्टडी ग्रांट करेगा. टाइप्स ऑफ कस्टडी. ओके, ये 3 टाइप्स है कस्टडी के. एक तो है सोल कस्टडी, ज्वाइंट कस्टडी, visitation rights. Okay, sole custody में क्या आता है? One parent is granted exclusive physical and legal custody of the child. Okay, एक ही parent को पूरा custody मिलता है, that is physical and legal. Joint custody में both parents share physical and legal custody of the child and they are involved in making decisions regarding the child's upbringing. So both the parents joint custody में are involved in making decisions regarding the child's upbringing. There have visitation rights. Even if one parent is granted custody, the other parent may be awarded visitation right. The other parent may visit the child from time to time, allowing them to spend the quality time with the children regularly. For guardianship and custody, Hindu Minority and Guardianship Act 1956 governs custody and guardianship matters for Hindus. It considers the welfare of the child and the moral and physical fitness of parents when making custody decisions. Okay, age and preference of the child in many cases, especially if the child is older and mature enough to express. अगर child को समझता है कि किसके पास थोड़ा mature है और उनको समझता है किसके पास उन्हें रहना है, तो the court may consider child's wish as well. Welfare reports. In some instances, the court may order a social welfare report or consult child psychologists or counselors to assess the child's best interest. तो अगर ऐसे कुछ होता है तो the court may order a social welfare report or consult child psychologist. Psychologist को भी, children psychologist को भी refer कर सकते हैं या counselors को refer कर सकते हैं to assess what is the best interest of the child. Changing custody orders. Custody orders are not necessarily permanent. कस्टडी ऑर्डर को चेंज भी किया जा सकता है. अगर फर्स्ट टाइम में अगर वाइफ को दिया गया हो तो मे बी द हस्बैंड में आल्सो गेट द कस्टडी ऑर्डर्स लेटर ऑन इफ सर्कमस्टांसेस चेंज. अगर सर्कमस्टांसेस चेंज होते हैं एंड इट इज इन द बेस्ट इंटरेस्ट ऑफ द चाइल्ड, तो कस्टडी ऑर्डर्स कैन बी मॉडिफाइड, उसमें चेंजेस किए जा सकते हैं. Enforcement of custody orders. Once custody is awarded by the court, both the parents are legally obliged to adhere to the court's decision. एक बार custody orders दिए गए हो तो दोनों को custody orders को सुनना ही पड़ेगा. Whatever the decision of the court is, failure to do so can lead लीगल कॉन्सिक्वेंसेस, अगर नहीं मानता है कोई तो फिर उसके भी लीगल कॉन्सिक्वेंसेस हो सकते हैं. Legal representation, it is advisable for both the parties to seek legal counsel during custody disputes to protect their children's rights and interests and ensure the best interest of the child. Uniform Civil Code. Okay, it is important to note that India does not have uniform civil code for all citizens and personal laws often apply. Therefore, the specific provisions and procedure for child custody may vary based on personal laws applicable to the parties involved. Personal laws भी जो हमने पढ़े कि हर religion के साथ उनका एक personal law है, तो उसके भी कुछ laws applicable हो सकते हैं. Okay. Landmark judgments. Again, this is the last part. Don't stay tuned. So Shaira Banu versus Union of India. In this case, Supreme Court declared the practice of triple talaq, that is instant divorce, among the Muslims as unconstitutional and stating that it is violated women's right and dignity. Then we have Daniel Latifi versus Union of India 2001. In this landmark case, the Supreme Court held that the Muslim woman could claim maintenance under the section 125 of the Code of Criminal Procedure from the husbands after the dissolution of marriage. Then we have got Dinshaw Mehta versus Minu Dinshaw Mehta. This judgment emphasized the principle of best interest of children when determining child custody and held that the welfare of the child is of paramount importance in custody disputes. Okay, then Chaturbhuj versus Sita Bai 2008. This case upheld the principle that financial capacity and means of both spouses are essential. Okay, financial capacity is also essential. Okay, factors to be considered while granting maintenance. Hello, sir. Sir. Okay, I think that was the last part. Let's conclude it over here. So by this, we come to the end of the lecture. Thank you for being there. Thank you for taking out time. And I'd like to mention that we have upcoming guest lectures. So and they are going to be extremely interesting. So don't miss out on those lectures. Stay tuned till the end of Navratri. And do attend the upcoming lectures. So tomorrow also we are going to have a guest lecture. So make sure you attend all of the lectures, upcoming lectures. Okay, with that, thank you everyone once again. Thank you, Keshav sir. So I think we have come to the end of the session.
Thank you everyone. Thank you.